Good afternoon. I'm Janae Nelson, President and Director Counsel of the Legal Defense Fund. We're just leaving the court after arguing Louisiana versus Callais, where the court asked some very challenging questions about the future of Section 2. We feel confident that if the court relies on its precedent, if it continues to have a commitment to the 15th Amendment and to this project of multiracial democracy, that it will rule in our favor. There has been no change in conditions or the law since it decided Allen versus Milligan a mere 28 months ago, where the court reaffirmed the constitutionality of Section 2, where the court rejected many of the specious arguments that our opponents have asserted on this second argument of the case. And so we feel very confident that the law is absolutely on our side. I want to take a moment, though, to thank our plaintiffs who have continued this fight, this battle, not only for fair congressional maps in the state of Louisiana, but fair legislative maps, fair judicial maps. It takes the will and spirit and courage of everyday people and voters to put themselves on the line, to commit themselves to often a very long and protracted project of ensuring our democracy. And while we are fighting for the rights for Black voters in Louisiana and across the country to have an equal opportunity to participate in our electoral process, that win is a win for democracy. It is a win for all Americans. It is a win for the rule of law. And that is why we fight, because we believe in the future of this country. And we believe that Black people have a right to be part of it and to self-determine who will represent them and to be part of the future of this country. And that is what Section 2 of the Voting Rights Act secures. And I'm happy to take your questions. Yes. If your question is the broader implications of this ruling, my hope is that this will put to bed the constant efforts to undermine Section 2 of the Voting Rights Act and the Voting Rights Act as a whole. There are constant challenges to its constitutionality. There are ways in which those states who are recalcitrant and do not want to abide by the Constitution try to litigate every factor of Section 2 and of our voting rights jurisprudence. I hope that the court writes a decision that is firm, that is airtight, and that forecloses any future challenges on those lines. Yes. I know that the court issued an extraordinary decision in a case that we argued, Allen versus Milligan, and won, even when people made the very same argument that this court would not necessarily rule in our favor. We have every confidence that this court will do its job, will follow stare decisis, and understands the import of this case, particularly in this political context where its legitimacy matters most.
We'll take 2 more questions and then we're going to the press conference.
Yes. Well, we're a nonpartisan organization. We bring this case on behalf of voters, regardless of who they vote for or what party they may or may not be affiliated with. What we care about is the right of every person to be able to vote without dilution, without discrimination. And that is our primary concern. We are not concerned with the objectives of political parties. Hearing no further questions. Thank you.
Thank you.